Welcome back to the deep dive. Today, we're embarking on a really crucial exploration into the architecture of justice. Specifically, we're looking at a set of procedural guidelines that came out of the Thai Office of the Judiciary back in October 2020.
Right, the Athron...
Exactly. And this document, it seems to have essentially redefined how victims of crime are treated, not just in theory, but, in the day-to-day operations of the courtroom.
It's a fascinating case study in legal reform, really. I mean, historically, victims all over the world have often been treated as just conduits for evidence.
Just a piece of the puzzle.
A necessary piece, but ultimately, secondary to the state's prosecution of the accused.
So our mission today is to unpack the specific and I think sometimes revolutionary measures that were put in place here. We want to see how Thailand moved beyond just a passive nod to victim rights.
Right.
And installed actual mandatory rules to ensure they're treated with dignity, psychological safety, and this is crucial given real influence over the outcome.
That's absolutely right. The core purpose of these guidelines is, well, it's ambitious. It's to elevate the standard of protection and practice in Thai courts.
To bring it in line with bigger standards.
Exactly. Aligning it with both the mandates of the Thai Constitution and, established international human rights standards. It's a very explicit attempt to shift the judicial culture toward one of mandatory courtesy.
Okay, let's unpack that. I think we have to start with the foundational principles, the ones that dictate how judges and court staff have to behave before any evidence is even heard. What is the non-negotiable baseline for treating a victim in this system?
This is outlined in the very first core mandate, and it's surprisingly direct. Judicial officials must treat victims with courtesy and respect.
Okay, that sounds like standard professionalism.
It does. But the rule goes further. It demands specific consideration for their feelings. The clear directive is to avoid any action that could cause distress or misunderstanding.
Avoidance of distress as a mandatory duty, that feels like a powerful, if maybe a little abstract, legal standard.
It is.
But how do you actually enforce courtesy or emotional consideration in a high-stakes adversarial environment? Isn't that incredibly subjective?
It is subjective, but by making it mandatory, it shifts the burden. It puts it on the court officials.
I see.
It means an official's tone, their posture, their whole communication style.
Yeah.
These are now procedural issues, not just matters of, personal temperament.
So if a judge is seen as causing unnecessary distress, that could be a breach of procedure.
Potentially, yes.
Yeah.
It codifies the recognition that the judicial process itself can be a source of trauma.
So the court has to actively manage the victim's emotional experience. And this concern, it extends beyond just the courtroom itself, right? I think the preamble mentions protecting privacy.
Correct. The mandate requires officials to actively preserve the victim's privacy and their rights regarding their safety, their social status, their daily life. The document explicitly acknowledges that just participating in legal proceedings, having your trauma dragged out into the open can devastate these parts of a person's life.
So the court has to stop its own machinery from doing more harm.
That's a great way to put it.
But what really struck me was the victim's input into the procedural decisions, not just at the end during sentencing.
Yes.
The guidelines say courts must actively consider the victim's opinions and concerns when making these procedural calls.
This is where the victim starts that journey from being, like we said, a passive witness to being a more active party in the case.
Right.
Traditionally, the court dictates its own timeline. Under these rules, if a victim explains that a certain step, say a long delay or how evidence is presented, will cause them undue suffering, the court has to integrate that into its decision.
Their personal recovery goals actually become relevant to the judicial workflow. That sets us up perfectly for the next step, the procedural safeguards during the trial itself. Because the court admits the process can be traumatic, what concrete steps are required to ensure safety during the most stressful part?
This is tackled head-on in Section 2, with a big focus on separation and sensitive testimony.
Okay.
These rules really target cases with minors or domestic violence or really any offense where public sentiment is high and the risk of confrontation is significant.
So what exactly must the court do to prevent that face-to-face confrontation between a victim and a defendant? That seems like it could be incredibly re-traumatizing.
The court is mandated to actively take measures to prevent it. And the solutions they suggest are very practical.
Like what?
Well, things like ensuring separate waiting areas, so the victim doesn't have to wait in the same hallway as the alleged offender.
Simple, but makes a huge difference.
A huge difference. But the most powerful tool is probably the use of technology, like arranging for testimony via remote systems. Video conferencing, for example.
So the court can use a remote feed. That ensures the victim can testify fully and honestly without the stress of having the alleged perpetrator, right across the room.
Precisely. It acknowledges that physical proximity can inhibit truthful testimony and just compound the trauma. The tech becomes a shield.
That feels very modern, very pragmatic. But physical safety is one thing. What about verbal safety? The questions being asked can be even more invasive. The guidelines seem to lay down pretty strict restrictions on the line of questioning, which is a massive departure from the idea that cross-examination should be, unrestrained.
It's a radical step. It really is. These restrictions are designed to stop the victim from being put on trial themselves, which is a common phenomenon, as you know.
Of course.
The guidelines explicitly list 5 prohibitions that courts have to enforce when a victim is being questioned.
Let's go through those 5, because they seem to fundamentally change the game for attorneys in Thailand.
Okay, so the first is clear. No asking unnecessary questions about the victim's personal life or conduct. This is a direct shot at character assassination attempts.
Right.
Second, officials cannot expose the victim to the alleged offender unnecessarily. Third, and this is simple, intimidation is explicitly forbidden.
Straightforward enough.
Fourth, they can't disclose unnecessary personal details of the victim in court.
And the fifth one, that deals with skepticism, doesn't it?
It does. Courts are restricted from performing checks on the victim's credibility without due reason.
That is a crucial procedural break.
It is. It means the assumption that a victim is inherently unreliable and has to be, rigorously vetted, that's been formally challenged. The questions have to stay focused on the facts of the crime, not the victim's past.
That is a profound restriction. It forces the whole proceeding to focus on the actions of the alleged offender, not the lifestyle of the person who is harmed.
It elevates their dignity instantly.
And if a victim feels any of these rules are being broken, they can ask for help right then and there.
Exactly. The system is designed to be responsive. If a victim requests protection for their safety, their assets, their privacy, the court is empowered to order officials to provide measures immediately. It's an emergency response mechanism.
We've established the foundation of courtesy and these mechanisms for psychological and procedural safety. Let's shift now to the final, and I think most compelling section: restitution, compensation, and the victim's influence on the outcome.
Section 3. This is where the court becomes, in a way, an active resource center for the victim.
Wow, that's a great way to put it.
The guidelines impose a proactive duty to inform. The courts have to clearly explain a victim's rights to seek compensation. And this is critical, actively assist them with the bureaucracy.
So they aren't just handing you a brochure.
Not at all. They're meant to help you navigate the process of applying for compensation, for governmental assistance, whatever benefits are available.
And how does that service role extend into restorative justice, like mediation?
This is item 8. The courts should help bring the parties together, the offender and the victim, to reach some kind of reconciliation or mediation agreement.
And the goal isn't just to save the state time.
No, the stated goal is to ensure the victim receives fair, swift, and comprehensive compensation. It recognizes that sometimes the state's slow, punitive process doesn't really address the victim's immediate needs.
So if we look at the whole structure, the Thai judiciary is trying to maximize 2 things: the victim's psychological safety and their financial restoration.
I think so.
This moves us to maybe the most radical provision: the connection between the victim's perspective and the actual sentencing under item 9.
This really is the heart of the restorative philosophy here. The court is explicitly required to consider the victim's opinion and the damage they've suffered when determining the punishment.
So the victim's narrative gets substantial weight.
A lot of weight.
But here's where it gets, as you said, really interesting: the power of forgiveness. If the victim forgives the perpetrator, the court is given explicit permission to step away from conventional punishment.
That's the key mechanism. It elevates the victim's agency above the state's, punitive impulse.
So if reconciliation happens,
If it's achieved, the court can choose alternative measures. And these aren't minor concessions. We're talking about potentially replacing imprisonment with things like community service or a structured payment of damages or detailed restitution plans.
that is a huge concession of state power to an individual victim. If I forgive the person who harmed me, I can essentially steer the court toward making them repair the damage directly.
Instead of just disappearing into the prison system, yes.
What are the potential issues with that? I mean, does this create friction with the state's duty to ensure public safety?
It absolutely raises philosophical questions. The intent here is to prioritize outcomes that benefit the victim and prevent reoffense through repair, not just retribution.
But there must be a balance.
Of course, the system has to balance it. If the offense is severe or the offender is a high risk to the community, forgiveness alone probably isn't going to override the need for public protection. But in many, non-capital cases, it provides a structured path for the victim to get closure through restoration. It makes the victim an architect of the outcome, which is globally very unusual.
It acknowledges that for a lot of victims, justice isn't just locking someone away, it's seeing the harm repaired.
Exactly.
So let's say a verdict is delivered, compensation is ordered. The court's job still isn't done.
No, it continues all the way through to enforcement. Item 11 ensures prompt post-verdict notification. The victim must be immediately informed about the judgment and their rights.
And they don't have to pay for that information.
It has to be provided without any cost to them. They shouldn't have to pay to know the outcome of their own case.
And finally, item 12, the court as an enforcement assistant.
Yes. If the judgment includes an order for compensation or restitution, the court has to actively assist the victim in the enforcement process.
Which means
It means coordinating with enforcement officials, providing information, giving support. It recognizes that a piece of paper awarding you money is meaningless if you then have to fight the bureaucracy to collect it. The court closes the loop.
this has been a fascinating deep dive. It shows a highly sophisticated legal structure mandated in 2020 that views the victim holistically.
It does.
It covers basic courtesy, robust psychological protection, and, most impressively, this massive shift toward restorative justice, giving the victim real agency.
What stands out to me most is that these guidelines don't just offer best practices. They mandate proactive action at every single stage. From the initial sensitive questioning all the way through to actively helping collect compensation, the entire judiciary is mobilized for the victim's recovery.
That emphasis on avoiding confrontation, on using technology, on promoting reconciliation as a path to alternative sentencing, it really sets the system apart.
It does.
And it begs a profound philosophical question for all of us to think about. Considering this mandate allows a victim's act of forgiveness to potentially steer a case away from traditional prison time and toward restitution, how does this emphasis on restorative elements fundamentally change the purpose of a criminal trial? What is that ideal balance between the state's need for public punishment to maintain order and the victim's deeply personal path toward genuine reconciliation and repair? That balance is what these guidelines are actively trying to redefine.
A powerful thought to consider. Thank you for guiding us through this.
My pleasure, and thank you for joining us for the deep dive. We'll see you next time.